Good evening and welcome back to the current affairs lecture that we have been doing for this year. So after the exam, the prelims, I hope it was good for you, those who appeared. And there were many questions from our lectures as well. There were 2 questions from mapping and both were from our lectures, the mapping practices that we have done. And we have taken those questions today also, we'll be discussing them. And most of the questions from economics, as I have always stressed, economics is the most important topic. The economics is most important topic because the economy of India and static portion of economy, what is going on in the world, it is all related very much to economy and polity, of course. Okay. So the current affairs section, you have to stress upon a lot upon this current economy and polity. Okay, and you might have observed the topics I choose, they are mostly from economics. Like there was one question about indirect transfers and we have discussed twice. We have discussed indirect transfers twice, one in the Vodafone tax dispute case and one in one lecture in the last week itself. Indirect transfers, we were discussing indirect transfers, and you should understand that these are very important topics and you have to focus a lot on these. Okay, but I believe a basic understanding of economics is also important and you have that. Okay, now we will start our lecture with the first topic that we are having at hand, that is Surrogacy Regulation Act 2021. In 2021, 2 important acts was passed regarding the reproductive rights of women. The first one is ART Act, Assisted Reproductive Technology Act 2021, and the second one is Surrogacy Regulation Act 2021. Now Surrogacy Regulation Act 2021 brought about a certain legal dimensions to the already legalized surrogacy in India. The surrogacy was legalized in India in 2003 itself. Okay, now we'll see how this surrogacy law has affected changes into our system. Now, why news? Because outsourcing childbirth will allow me to live freely, says petitioner who challenged surrogacy law. One woman who is a working woman has challenged this surrogacy law in the Supreme Court of India and said that outsourcing childbirth will allow me to live freely because women usually have to take leaves and leave from their work, due to which most of the women are put out of the workforce because of the certain demands of child rearing. Okay, at least 2-3 years they have to pull back from their work for at least 2-3 years because of this child rearing demands. Okay, so these working women are saying that if we are given an option of commercial surrogacy, so that will allow them to remain in the workforce and work like their male counterparts. Okay. The second news is allows surrogacy for single men and mothers. The second petitioner in this case is a single man who is asking that he should also be allowed to have surrogacy. Okay, and actually there are a lot of other challenges to the law itself, and we will be dealing with them as to how this law falls short of the demands and needs of the current society and what should be done for that. So a petition has been filed. A petition was filed before Delhi High Court, not Supreme Court. Apologies for that. A petition has been filed before the Delhi High Court challenging the exclusion of a single man and a working woman, like a woman who is already having a child, so they cannot go through, they cannot use surrogacy route to have another one. Okay, the petitioners have challenged the exclusion from availing surrogacy under ART, Assisted Reproductive Technology Act, and Surrogacy Act 2021. Okay, so these 2 laws have prohibited these people from having children through the surrogacy route. Okay, now we will look how these laws are preventing them. A basic history of evolution of surrogacy laws. In 2002, surrogacy was legalized. Okay, prior to that, surrogacy, there was no law dealing with the surrogacy. Okay, now what is surrogacy? Surrogacy, as the act defines, is having children from non-biological parents. Okay, basically we'll be dealing with that in a while, but I believe you have a basic understanding what surrogacy is. In 2008, Baby Manji Yamada versus Union of India case. In this case, what happened was, this baby, actually a Japanese couple commissioned a surrogate mother in India, and then some dispute happened, and then the case went to the Supreme Court. And this case brought about a lot of ethical dilemmas involved in the surrogacy laws in India. Okay, and that case was a watershed moment in the evolution of surrogacy law in India. It brought about a lot of ethical perspectives along with the legal ones. Okay. फिर 2016 में a bill was introduced in Lok Sabha, and 2019 में bill, actually the bill did not pass, okay, because of the dissolution of Lok Sabha. And then 2019 bill was again introduced in Lok Sabha, and 2022 में the bill was enacted as an act. Okay. So this is how the evolution of surrogacy law in India has taken place. Now surrogacy, as the act defines, okay, as the act defines, means a practice whereby one woman bears and gives birth to a child for an intending couple with the intent of handing over such a child to the intending couple after birth. That means one woman who is not biological mother of the child that she is going to bear is going to be going to give birth to a child, okay, give birth to a child for someone else. Okay, here intending couple, one important point to note here is intending couple, the couple who intend to have a surrogate child. Okay, this is defined as surrogacy. Now surrogacy has been classified in two ways in this act, okay, and no other surrogacy is allowed. The first one is altruistic surrogacy, and the second one is commercial surrogacy. The act primarily bans commercial surrogacy. That means although the act defines commercial surrogacy, but at the same time it also bans it. Altruistic means selfless, basically such a surrogacy where the person who is becoming the surrogate mother is not charging the person or charging the intended couple, and that is why it is called altruistic surrogacy. The act, of course, the expenses of pregnancy and the childbirth and other such related costs will be, of course, covered by the intending parents, but that surrogate mother is not going to get a pecuniary benefit out of it. Okay, that they will not be commissioning a surrogate mother for some specific monetary amount. Okay, and then it also restricts what kind of people can become surrogate mothers. Okay, so altruistic surrogacy means surrogacy in which no charge, fees, remuneration or monetary incentive, no kind of monetary incentive is provided to become a surrogate mother, or whatever nature. It can not only be monetary but other kind also. Like one can avoid a monetary path by going through the route of property transfer. Okay, such a lot of things can happen. Okay, so that is also prohibited except the medical costs and such other prescribed expenses incurred on the surrogate mother. Okay, of course the incidental incidental expenses to the surrogacy or the pregnancy will be taken care of by the intending couple, but a remuneration, a reward, a monetary reward cannot be provided for a surrogate in lieu of a surrogate mother. Okay, I hope you understood that. Now commercial surrogacy is simple, buying or trading motherhood. Okay, like by giving a monetary compensation, reward or payment. So I hope you understood commercial, that is called commercial surrogacy. But commercial surrogacy has been specifically banned in India. One cannot practice commercial surrogacy. Earlier what happened was, prior to enactment of this act, a lot of women Basically, the poor women became surrogate mothers in exchange for some monetary compensation. And a lot of times, such women were not compensated properly. Not compensated properly. Moreover, the mothers who became surrogate were most of the time the poor women. So it became a kind of a womb market, okay, and a very strong sentiment against this commercialization of a womb came into existence, and a public opinion was formed, and a public opinion against the commercial surrogacy was formed. That led to the enactment of this act. And many times many things happened, like the rights of the children who were born out of this surrogacy contracts, they were sometimes in conflict with the law, as the intending parents, who were mostly foreigners, okay, the intending parents were mostly foreigners. What they did was they did not like they commissioned the surrogate mother, and after a point they did not come to have their child. Many cases like this happened, and then multiple number of children, such children were created who were in conflict with the fundamental laws. So of course the children will be taken care of by the state, if not by the surrogate mother. But then a law was required, because there was a legal vacuum in this sector to persecute or to prosecute the offenders. ठीक है. And moreover, a very important point to note here is also there was a very strong moral opinion against commercial surrogacy, or as we can say, a marketplace of wombs. It was called, in a very emotionally charged statement, it was called a marketplace of womb, and people did not want that kind of marketplace to exist. Okay, if a person is selling their bodily autonomy. But then also a second part of this debate, the moral debate of surrogacy, is that women might want to women might want to have a commercial compensation. Some poor women might want to have a commercial compensation in lieu of selling their wombs, and the right and the choice of making the right to make that choice, whether they want to have it or whether they do not want to have it, should be solely of the mother. That is a feminist opinion on this issue. Okay, so we have to make ourselves aware of the both the sides. Okay, that is very important. Okay, and moreover, this law, this act which prohibits commercial surrogacy, it has been criticized over the aspect that the law has become need based instead of rights based. What it has, the law has become needs based. Sorry, the law had become need based instead of rights based. Okay, the law have become need based. Need based means the people who are in need of having a child due to certain kind of limitations upon their abilities to produce children, so they can go through, they can avail surrogacy. But the people usually who are not medically unfit to procreate, they cannot go through. Matlab, it takes away the right of every person to have surrogacy. Rather, what it does is it puts a limitations upon our rights. It take away rights, and it makes surrogacy a need based thing. Certain qualifying criteria has been prescribed in the law that we are going to look through, and therefore a lot of criticism this act faced was due to the fact that it has become a need based rather than the rights based. Okay, now we have seen this. Who can avail surrogacy? Infertile Indian couples. Now, in the last slide we saw intending couples. Very important point is foreign couples cannot be an intending couple. Okay, only Indian couples can be intending couples. Second important point is, it is who can avail surrogacy? Only infertile Indian couples. And the second point is, it was later added into the act, the widowed women or the divorced women, the women who are divorced. Okay, these two additions were done later. That means only couples can either couples can have, or a divorced woman or a widowed woman can have a child through surrogacy. On the other hand, the changing reality of our times is that even Supreme Court has considered live-in relationships legal, right? But this act does not provide people who are in live-in relationships the right to have children through surrogacy. Understood? And secondly, single men and single women who are not married, okay, and who are not divorced, who are not widowed, they cannot conceive children through the route of surrogacy, either commercial or altruistic. Understood? So infertile Indian couples, they need to take an essential certificate. Okay, they need to take a certificate from the district magistrate, who will determine, basically a medical board will be constituted, sorry, and that medical board will determine the eligibility of that couple who are and the eligibility will be these points that we are going to discuss. That means a medical board will be constituted. That medical board will recommend to the DM, the district magistrate, that yes, that specific couple is medically or is biologically unable to procreate, and they qualify the certain criteria that have been set in the law, and they can be given the right to procreate through the route of surrogacy. Now, what kind of people can avail surrogacy? Infertile Indian couples who have been married for at least 5 years, okay, have been married for at least 5 years, and the wife should be aged between 25 to 50 years, while the husband should be aged between 26 to 55 years. Okay, now this age limit and the specifics of the specifics of the time limits, even in married couples cannot have surrogacy unless they are at least married at least for 5 years. That means the government is putting a lot of stress upon the fact that the people who have tried enough to conceive through the natural route, okay, and they are just not going through the shortcut of this surrogacy. Okay, the couple must not have any living child. Okay, the couple must not have any living child, biological, adopted or surrogate. Okay, and the child with mental or physical disabilities or one suffering with life-threatening disorder, that is an exception. If a person is having a living child, but that person is suffering from some life-threatening medical disability or mental disorder, so then the people, that couple can go for surrogacy. Okay, understood? Now, this I already told. This is passed by a magistrate's court. That must also, and very important point is, after all these things, the couple should also secure an insurance for the intending mother, the mother who is going to be a surrogate, for at least 16 months, okay, covering any postpartum complications. Postpartum complications means the complications that arise after the childbirth. Okay, तो 9 months का gestation period minimum, and then उसके बाद का जो 7 months के around postpartum complications से fight करने के लिए the intending mother will be provided with a medical insurance by the intending couple. Okay. And second, people, widowed or divorced women can also have surrogate children. Foreigners cannot avail surrogacy in India. And very important point was that prior to this act, the major customers, the major consumers of this surrogacy, commercial surrogacy, were the people from foreign countries. Okay, because the cost of surrogacy in India was low, because they, of course, they exploited the poor women at a very fractional costs. Okay, and commercial surrogacy is not allowed. That means the intending couple cannot go for a commercial surrogacy. They cannot buy or purchase a womb. They will have to look for a person or a woman who is naturally related to them, and she is a relative, and she is doing it pro bono. Okay. So who can be a surrogate? A surrogate mother has to be a close relative of couple. Okay, a surrogate mother has to be a close relative of couple, a married woman, it should be a close relative. They should also, that woman should also be married with children, with a child of her own. Not only should be she married, she must have at least one child of her own, and the age between 25 and 35 years, and who has been a surrogate only once in her life. That means the intending mother can, one woman can be surrogate at max twice in their life. Okay, so these are the specific criteria, and she must also possess a certificate of medical and psychological fitness from the, of course, from the medical board for surrogacy, right? So these are the limitations that have been put upon the intending mothers who want to be surrogate. Now, this act establishes two kind of bodies to regulate such surrogacy in India. The first one is National Surrogacy Board, and the second one is every state will be having its own state surrogacy board. Okay, this body is tasked with enforcing the standards for, okay, along with this, as I told, ART Act also came, Assisted Reproductive Technologies Act 2021. Now, what is assisted reproductive technology? Assisted reproductive technology is any kind of technology that helps people in having children through assisted methods, medically assisted methods. Okay, like IVF, inter vitro fertility, and all these kind of methods. The people who are infertile, they can go through this some artificial reproductive technologies, and they can help the people in conceiving a child. So surrogacy and ART run parallel to each other. Okay, and surrogacy clinic needs to apply for registration. If there are any surrogacy clinics in India, they will have to apply for the registration to State Surrogacy Board and the National Surrogacy Board as well. Okay, offenses have also been provided. When offenses have been provided, okay, that means the violation of law is a criminal offense. If the offense is of jail or imprisonment, that means the violation of the law is a criminal offense. But in case only financial penalties are imposed, in that case the law is a civil offense. In this case, like adultery is a civil offense. One cannot be put into jail for committing the crime of adultery. However, if one commits the crime of violating the surrogacy law, so they can be imprisoned for 10 years, for up to 10 years, or a fine of up to rupees 10 lakh, or both. Okay, so that means the violation of surrogacy is a criminal offense. So the petitioners have argued, that this act violates the right of privacy under Article 21, and of course the right to life. Okay, because they have argued that the right to life includes the right to procreate as per one's bodily wish. Okay, and the state does not has a locus standi into getting into the lives of people, into and looking into what kind of choices they are having with respect to having babies. Okay, the state, that means the petitioners argue that the state does not have any kind of right to enter into the domain, the personal domain of personal lives of people, and looking into how they are going to have children. Secondly, it also violates the right to privacy under Article 21, because procreation and having children is a very private domain of one's life. The state should not have any legitimate concern with the people, with the state should not have any legitimate concern with people, how people are having children. Okay, if the parties are consenting, so they should be allowed to have commercial surrogacy as well. Okay, so this is what the petitioner's argument is. And secondly, they have also argued that the limitation that has been imposed, ki only couples can have, only married people can have children through surrogacy, is also out of the line with the Supreme Court judgments and also out of the line with the contemporary realities that the times we are living in. We have live-in people, live-in couples, okay, people who are not marrying but living together, and this is the contemporary reality. The law ignores that reality and tries to impose a certain kind of morality upon people, okay. So it divides those people who are living in from the access of surrogacy, which is violative of their fundamental right under Article 21. This is what the petitioners argue. I hope you understood the surrogacy law and what it talks about, how it has changed, how it is out of the sync with the contemporary realities, and what are the changes that we need to do to make this an inclusive law. It should be a law that facilitates that facilitates people having children and not restricts the methods from which the people can have children. Okay, this is what the Surrogacy Act, and this is what the criticism of the Surrogacy Act is. And we have of course dealt with the sections and the important provisions of this act. If you have any queries, you can ask me in the comment section.